Greetings to one another. You are listening to MMJC updates. In today's edition, we will be discussing about two amendments, one of which is relating to disclosure of credit rating and another relates to IEPF. Post that, we will be discussing about two SEBI orders. So, moving on first to the amendments. The first amendment pertains to disclosure of credit rating given by the credit rating agencies. On 1st August, a circular has been issued by which it is said that now the credit rating agencies will be able to disclose the credit rating given by them to the companies directly to the stock exchanges. For this, the agency will have to register itself on the portal of the stock exchange, both NSE and BSE, after which it will be given a login ID and password through which it will be able to open a template and fill in all the relevant details there. After this, the credit rating given by the agency will be directly available on the website of the stock exchange. This is done to facilitate direct and quick disclosure and order and reduce human intervention in the disclosure process. Till the time all the credit rating agencies register on the portal of the stock exchange, the companies will continue to give manual disclosures. One more thing worth noting in this is that now onwards, the credit rating agencies will also be giving ratings relating to the unlisted debt securities of the company, which are not listed on the stock exchange and hence which were not given rating so far. The next update pertains to the IEPF, that is Investor Education and Protection Fund. So, previously, MCA had told the companies who had transferred some funds to the IEPF accounts who were in under 1956 Act, that is under Companies Act 1956, to file a form with the MCA to give disclosures in specified format with respect to this amounts transferred. However, some companies did not comply with this instruction. Now that all the forms, e-forms have been shifted to V3 portal and MCA, MCA has come out with a final deadline, that is 30th August, for filing of this form. Form IEPF-1A is required to be filed by the companies who have transferred the amounts under 1956 Act to IEPF account by 30th August in this form. The companies who will not comply with this will be subject to penalties. The next update pertains to a reform made by the Postal Department. So, Indian Postal Services have decided to close the registered post services from 1st September 2025. As we are all aware, all the official documents and documents relating to codes, etc., are served through registered post for the reason that it is very much address specific. The document is delivered only to a specific addressee and the sender gets the proof. Since this registered post service is going to be discontinued, there arise some problems. Like, for example, now through which means will the companies be able to send the official documents like AGM notices, etc. Even for that matter, the court notices or the government documents also. So, as far as Companies Act is concerned, the thing is that the sections wherever it is mandated to send the documents to registered post, it also says that we can send these documents through speed post as well. However, with respect to the facility of specific addressee, the post has made a facility in speed post wherein the speed post will be made addressee specific and acknowledgement receipt will be given to the deliverer, sender of the document. So therefore, with respect to companies and the problem is solved.
Moving on, we have the adjudication orders by SEBI. First is Karma Energies Limited. Karma Energy Limited is a listed entity of both on NSE and BSE. It entered a related party transaction last year, which was an intercorporate deposit worth rupees 4.62 crores with Tapi Energy Limited, another promoter group company of Karma Energy. SEBI's LODR mandates any material RPT like this one which is exceeding 10% of the company's turnover must take prior approval from the shareholders. NSE found discrepancies during its regular data cross-checking. The figures disclosed by Karma Energy didn't align with the reported data, which raised the red flag. NSE then sent a report to SEBI for further examination. SEBI's probe confirmed that Karma Energy had not obtained the required prior shareholder approval and only sought approval from the transactions was completed in January 2024. Additionally, Karma Energy had not updated its related party transaction policy since 2014, contrary to regulatory requirements for periodic review. For these violations of Regulation 23(1), 23(4) of the SEBI LODR, SEBI imposed a penalty of Rs 2 lakh under Section 15 HB of the SEBI Act. This case underscores the critical role of stock exchanges to play in monitoring compliance through diligent cross-verification and reinforces the need for listed companies to strictly follow procedural mandates around material RPT transactions and policy updating. Moving on, we have the HDFC case. In April 2022, the merger of HDFC Limited with HDFC Bank Limited was announced to the stock exchanges. The announcement led to a sharp rise, nearly 10% in the share prices of both companies. Following this, SEBI examined trades made just before the announcement and noticed unusual derivative transactions by Rupesh Dalal HUF. These trades stood out because the entity typically dealt in cash market, but on April 1, 2022, they had taken a very aggressive call option in both HDFC and HDFC Bank. This investigation revealed that a professional from Deloitte who had access to the merger information in his fiduciary capacity was a close associate to Rupesh's son. A record showed communication and personal meetings just a day before these trades. SEBI concluded that the trades were carried out while in possession of UPSI. Such conduct was found to be in violation of Regulation 3.2 and 4.1 of the SEBI PIT Regulations 2015 and Sections 12A, B, and E of the SEBI Act 1992. Accordingly, SEBI imposed a penalty of Rs 10 lakh under Section 15G of the SEBI Act. This case is significant as it demonstrates SEBI's increasing focus on connected persons of the fiduciaries such as consultants, valuers, and auditors beyond direct company insiders. Thank you for listening to the podcast. We await your feedback.